Hi, this is Nicholas Yock, a registered migration agent from Pathway to Oz. And today I'm going to discuss with you what happens if my visa gets refused. Specifically, this video is relating to what happens if your visa gets refused when you are inside Australia, so you're onshore. I will discuss, the process of appealing the decision, and I will also discuss your visa status once the visa has been refused. Please note, this information is general in nature, so I'd always recommend chatting with a migration agent to run through your specific circumstances. All right, so look, if your visa is refused, you will usually receive a refusal notice through email. This refusal notice will advise you the reasons for the refusal and give you a timeline for your next steps. Once you do receive the refusal, you can either choose to accept the decision or appeal the decision. If you accept the refusal and don't want to appeal the decision, your bridging visa that you hold will usually run for another 35 days from the time of receiving the refusal. So you have 35 days. This means you'll have either 35 days to leave Australia or apply for another visa if you are eligible to apply for another visa. Appealing the decision. This is where it gets interesting. So if you disagree with the decision and you want to appeal it, this is an option. In most circumstances, you will have 14 days to appeal the decision. And when you appeal a decision, guys, you're kind of saying, hey, I think immigration made an error when they made this decision, and I want to take this to a higher authority. This higher authority is the Administrative Appeal Tribunal. So in order to appeal the decision, you lodge an application for appeal with the AAT, or the Administrative Appeal Tribunal. You can quite often do this through their website. The cost is currently about $1,846. However, if you are successful, you will usually receive 50% of this back. Once you have paid the charge and the appeal is lodged, the bridging visa that you held at the time of refusal will usually continue into the future until a decision is finalised. Therefore, if you are on a bridging visa with full work rights, throughout the appeal process, you'll still have full work rights on that bridging visa. And if you're on a bridging visa with no work rights, you'll have no work rights. All right, so this is importantly, as recently processing times for appeals have just blown out. You can check on the appeals website to see exactly how long they expect it to take, but yeah, it's a while. In most visas, you're looking at least over a year. So in order to be successful for appeal, you need to provide documentation addressing the reasons why the refusal was done in error. Why did immigration make a mistake? So you can provide additional documentation, additional statements, medical information, education documents, work experience documents, etc. So the AAT member can either choose to accept, your documentation and agree with you without further comment, which is the best case scenario, or they can schedule a hearing. So during the hearing, you can present the reasons why the initial decision was made in error, go through the additional documentation, and you're given the opportunity to explain your situation. The member can ask questions to get further clarity, before they make a decision. Once all the information's been provided, the AAT member will then make a decision that either the case officer did not make an error, or the AAT member can say the original case officer did make an error. And if the original case officer did make an error, this application is usually remitted to immigration or sent back to immigration, who will usually take on what the AAT member said and will usually likely grant the visa. If the AAT member agrees with the refusal, you really have limited options. In certain circumstances, you can choose to take it to a higher court again, but it's starting to get expensive, and it's a whole other sort of ball game when you do take it after the AAT. We have assisted numerous clients take their applications to appeal, and fortunately, been quite successful with it. It's really satisfying knowing that immigration made a decision or an incorrect decision really, and then holding them to account for it. But obviously, it is a stressful time for clients and things like that as well. I hope you found this information helpful. As always, look guys, the information is general in nature, and I would always recommend to discuss your circumstances with a registered migration agent. Thank you.